Welcome to Video 4 of the Mine Health and Safety Act, focusing on legal liability. This video, document XT1777, was created in August 2025. Regulation 6.3 states that the manager must establish an election committee with employee representatives and potentially management representatives. Regulation 6.4 details the duties of the election committees, which include preparing election procedures and appointing officials. Regulation 6.6 requires every candidate health and safety representative to be nominated by shift and designated working place. Regulation 6.7 dictates that if only one candidate is nominated, they are declared elected. If more than one is nominated, an election must be held. Section 30 outlines the non-obligatory functions a health and safety representative may perform, serving as a pro forma selection. Companies may subsequently choose which of these functions to make obligatory for their representatives. The functions include reviewing health and safety measures, identifying hazards, and assisting employees in withdrawing from danger. Representatives may also inspect the workplace, participate in audits, consult with inspectors, and request investigations or inquiries under Sections 60 and 65. Representatives perform functions and receive training during ordinary working hours, with rights confined to their working place. Section 25(3) notes that a health and safety representative incurs no civil liability for acts performed as required by the Act. Employers must provide reasonable training as per Section 31(3)(b). Section 31 requires employers to pay full-time health and safety representatives equal remuneration to what they earned prior to appointment. The employer must also provide necessary facilities, assistance, and reasonable training. Furthermore, representatives must be given time off for agreed or prescribed training without loss of pay. Section 32 mandates that employers must notify representatives and the employee co-chairperson of inspections, investigations, inquiries, and any dangerous events. Regulation 6.12 outlines when a workplace representative must vacate office, such as upon completion of term, not meeting qualifications, or being requested to resign by 50% of employee members. Section 33 requires every mine with 100 or more employees to have at least one health and safety committee. This committee serves as a forum to discuss health and safety matters. Section 33(1) mandates employer negotiations with the representative union on a collective agreement for these committees. The agreement on health and safety committees can be combined with the agreement on representatives as per Section 26(1). It must cover the number of committees and members, election details, terms of office, vacancy procedures, meetings, and facilities. Section 36 sets out general guidelines for the committee's agenda, allowing the company to make certain functions compulsory. These functions include representing employees, participating in schedules provided for such issues under Section 97(2), and requesting a review of a code of practice. Chapter 2 of the Act outlines additional rights for the committee. Section 8 and Section 9 require employer involvement of the committee in drafting health and safety policies and codes of practice. Section 11 further requires committee involvement in risk assessment, program review, and incident investigation, including receiving copies of the investigation report. Section 16 requires the employer to provide the committee with copies of the annual medical report. Section 23 mandates committee involvement in drafting procedures for employees to exercise their right of withdrawal from workplaces. Section 37 requires the employer to provide the committee with necessary facilities and assistance to perform its functions. Section 102 of the Mine Health and Safety Act defines an employee as any person employed or working at a mine or works. This implicitly includes contractors as employees of the mine. Mining legislation prevents the mine from contracting out of vicarious liability for a contractor, meaning contractors are responsible for their actions on a mine. Upon training and competence of contractors and their employees, the contractor company should appoint personnel for supervision. On mines, the head of a contractor organization is commonly appointed as a Section 7.4 site manager, and contractor site supervisors are typically appointed under Regulation 2.9.2. Under Section 21, subsection 4, anyone who manufactures, imports, or supplies hazardous substances must ensure the substance is safe when used, handled, processed, stored, or transported, and poses no health and safety risk. Required information includes proper usage, potential risks, restrictions, safety precautions, emergency procedures, and disposal. A process must be established for suppliers to provide information sheets on hazardous substances, following a uniform format set by the employer. For companies, sheets must include information listed in the Hazardous Chemical Substances Regulations to the OHS Act and Annexure 8. For mines, MHSA Act Section 21.4c information is required, but Annexure 8 to the OHS Act is advisable as a minimum. Hazardous substances are classified into 4 groups. Group 1 includes primary substances causing injury. Group 2 covers compounds that may cause injury. Group 3 comprises electronic devices. Group 4 includes radioactive materials used for purposes other than nuclear power cycles. Regarding packaging and handling, substances must be packaged per SANS Code 0229. Regulation 10 for Group 1 substances states that Category B containers should only be used for such substances and not for foodstuffs or cosmetics. Regulation 9 for Group 3 substances mandates formal notification to the Minister of Health before modifying any licensed electronic product. Section 6 of the MHSA addresses personal protective equipment, requiring every employer to supply and maintain necessary health and safety equipment in a serviceable and hygienic condition. Employers must also ensure sufficient protective equipment is available and employees are properly trained in its use, maintenance, and limitations. PPE training, as per Section 6.3, should cover reasons for wearing PPE, proper usage, cleaning, maintenance, and the need to hand in old or damaged equipment. Training should include fitting sessions for customized PPE, with routine evaluation and investigation of noncompliance. Legislation requires PPE to be supplied and used wherever risks to health and safety cannot be adequately controlled by other means. PPE must be properly assessed for suitability, maintained and stored correctly, provided with instructions, and used correctly by employees. This image visually represents the Mine Health and Safety Act and the focus on personal protective equipment. MHS Act Section 24, titled Employees Not to Pay for Safety Measures, prohibits any deduction from an employee's wages or payment from an employee for anything the employer must provide under the Act for Health and Safety. An employer cannot charge employees for PPE, including agency workers considered employees. If employment terminates and the employee keeps the PPE without permission, the employer may deduct the replacement cost from wages owed, provided this is stipulated in the contract. For maintenance, equipment must be well looked after and properly stored when not in use. It must be kept clean and in good repair, following the manufacturer's maintenance schedule. Simple maintenance can be done by the wearer, while intricate repairs should be handled by specialists. Suitable replacement PPE must always be available. Incident reporting is critical. Certain incidents in the mining industry must be reported to the Department of Minerals and Energy in a prescribed manner and form. Chapter 23 of the Regulations to the Mine Health and Safety Act, 29 of 1996, details the incidents that must be reported. Incidents that must be reported to the Principal Inspector of Mines, or PIM, include death, injury likely to be fatal, unconsciousness or incapacitation from heat, fumes, or electric shock, injury causing incapacitation of 14 days or more, loss of limb, permanent disability, or injury causing incapacitation until the next shift or day. Dangerous occurrences that must be reported to the PIM include rock bursts and falls of ground, caving, flow of broken rock, breakdown of main ventilation fans, power failures, fires and explosions, flammable gas incidents, issues with winding plants, lifts and elevators, objects falling down shafts, emergency or rescue procedure failures, self-propelled mobile machinery incidents, and boiler and pressure vessel failures. Additional dangerous occurrences to be reported to PIM include incidents involving chairlifts and explosives. The employer must have a system for immediate incident notification, maintain a record of particulars, and keep this record for 2 years from the date of notification to the PIM. The Mine Health and Safety Act, Section 11.5, mandates a systematic and formal approach to incident investigation, including looking into the underlying or root causes. The MHS Act Section 50 outlines an inspector's powers for inspections and investigations. These powers include entering a mine without a warrant, entering other places with a warrant, and questioning any person at the location. Further inspector powers include collecting and copying documents, questioning persons about those documents, inspecting conditions, and inspecting medical surveillance arrangements. An inspector can also instruct a person to appear for questioning and remove substances for analysis. The inspector functions as a health and safety policeman, ensuring compliance with the Act. However, they are also meant to assist employers and employees in maintaining a safe and healthy workplace. Cooperation is expected, but potential statutory penalties must be remembered during questioning. Section 54 grants inspectors the power to deal with dangerous conditions. This includes issuing instructions to halt operations, suspend acts or practices, set conditions for corrective action, and instruct the movement of persons to safety. Section 55 addresses an inspector's power to order compliance if they believe the Act's requirements are violated, specifying what must be done. Section 56 requires the employer to provide copies of instructions to relevant representatives and committees, display the instructions, and verbally communicate them to affected persons. Section 52 of the MHSA Act requires employees and the owner or employer to assist the inspector and provide necessary facilities during a visit. Any person must answer the inspector's questions, although they do not have to answer if it would incriminate them. Under Section 53, any person must produce documents required by the inspector, which include certificates, permits, checklists, and logbooks. Section 62 reiterates the duty to answer questions during an investigation, unless self-incrimination is a risk, unless protection under Section 63(3) is arranged. Sections 57 to 59 grant the right of appeal. Any person affected by an inspector's instruction can lodge an appeal with the chief inspector within 30 days. This also applies to instructions from a principal inspector. The chief inspector must promptly decide whether to uphold, set aside, or amend the instruction. If unhappy, the person can appeal to the labor court within 60 days. The instruction remains binding during the appeal, unless the appeal concerns a fine under Section 55, in which case the fine is suspended. Section 61 addresses discretionary investigations, allowing the inspector to investigate any health and safety practice or suspected violation of the Act at any time.